SJC-12355, Tara Dorrian, and another V, LVNV Funding, LLC.
Mr. Schultz, good morning.
Mr. Chief Justice, may it please the court. LVNV has raised a number of issues in this appeal, and we're probably not going to get to all of them, but the most important is the first issue in regards to licensing. My client has been sued for not having a license, though it was told by the Division of Banks that issues the license it does not need one.
Do you know, when was it told that? Couldn't
There
find
was
the date.
it was told specifically in a letter in 2012. There was previous letters that were, quote, industry letters in 2006, two of them, a follow-up letter in 2014, another letter in 2017, and then obviously—
Had a letter in 17?
There's another letter to Midland
okay.
in 17, but the one in 2012 was directly to Barbara Sinsley, the
Okay.
counsel of LVNV. We've also know from the amicus brief that was filed 2 weeks ago by the division that they would not process an application. Not only were they told not to get a license, they could not get one processed if they sought one. The question then becomes whether or not they need one, and that gets us to the definition of a debt collector under the MDCPA Section 24. That definition follows the Fair Debt Act, the federal law that was passed in 1977. And it has two parts. The definition has two parts. It says, is your principal business the collection of debts? Principal business, the collection of debts. Or are you directly or indirectly collecting debts owed to another? Both of these issues have been addressed in the pleadings, in argument below, before this court. As the trial judge addressed and largely relied on the second definition, directly or indirectly collecting debts owed to another. That was done previous to the United States Supreme Court addressing that exact clause in a case called Henson versus Santander. The Henson versus Santander—
It's not crystal clear she's not relying on both, is it? Because she sort of moves back and forth a little bit, doesn't she?
She does move back and forth a little bit. It seems that what she ultimately decided was that that portion of the definition was the one that was applicable to it, and how she got there in part was going beyond the definition, though. She went beyond Section 24, and she went into 24A, and I think it's on page 21 of the opinion, and that's, I think, part of how there was, I call it an error in the analysis, the legal analysis of the structure. Instead of sticking with the definition in 24, she then paraphrased Section 24A and did so incorrectly and referenced directly or indirectly collecting debts in the Commonwealth. But that is not the portion. Directly or indirectly is not in the definition except if you're directly or indirectly collecting debts owed to another. And that's what the Supreme Court was addressing, is a question of whether a debt buyer who was collecting its own debts was covered by that portion, and the court said no, it wasn't. So I don't think reliance on the second definition covers LVNV, because it's certainly not. If it's doing anything, it's not collecting for someone else. Judge Sanders did not have the benefit, obviously, of the Santander opinion. It came out after it came out the beginning of the summer. The first part of the definition then is principal business. Is the principal business of LVNV the collection of debts? Now, the facts associated with what it does is really not in dispute. And the Division of Banks has been clear that it does not view its principal business as collection of debt. LVNV acquires assets. It's more often than not defaulted debts, more often than not in connection with this case, credit card debts. It holds those, but it has a master servicing agreement. It's not a tremendously uncommon practice, as the court may.
So what's your understanding its principal business is investing in debt?
Acquisition. Yes.
It's what?
It's the acquisition and ownership of debts. All of the collection activity is taken pursuant to a master servicing agreement with a licensed debt collector, Resurgent. It's been licensed in Massachusetts since 2002.
But if you can't collect, you don't have any investment, right? I understand the division sort of draws that line. I'm just trying to understand intellectually how that works. Isn't one completely dependent on the other? The investment is really based on the success of the collection, isn't it?
Well, if you look at the definition, we're talking about is its principal business collection of debt. Those are the terms that are used in the Act. And what we're saying, and what the division has said, and what a number of courts have said, is that if all they're doing is they're acquiring the asset and then the actions are being taken by licensed debt collectors or lawyers, that doesn't make their principal business collection of debt. So how does it happen? Well, Resurgent has the accounts. They have the records for the accounts. They have employees. LVNV has no employees, doesn't make any phone calls, doesn't send any letters. Resurgent does the collection. It can choose to collect an account, to settle an account, or not to collect an account. It has full discretion. It can choose to send those accounts to other entities. It can decide, as it did in these instances, that these qualify for litigation. In that instance, they'll retain counsel, typically experienced in this field, and then those lawyers take over. The lawyers prepare the pleadings. They obtain records from Resurgent. They will file the lawsuits. They'll serve summons. They'll file the pleadings. If they need affidavits, those affidavits come from Resurgent, the licensed debt collector. If they need witnesses at a trial, those will be Resurgent employees. So,
But the lawyers are suing on behalf of LVNV.
LVNV's name will be on the complaint, just like it will be on the
It's their claim. They are the
plaintiff in the litigation.
right.
Right, but does that make their principal business the collection of debt? And our position and the position of the division and a number of other cases is it doesn't make their principal business the collection of debt.
What's their other principal business?
It's the ownership and it's the acquisition and ownership of the assets, and that's what it does. And there's a number of other entities like that are referenced in the amicus briefs. The division is quite aware of this, and they've issued, like I said at the beginning, numerous opinions that a license for it is not required. And you asked for amicus.
But the assets are the debts, right?
Yes.
Yeah, so the acquisition and ownership of the debt, right, yeah.
Correct. Right. Typically it's a defaulted debt. And it could be performing, but it's
Now,
typically
is there a
defaulted.
difference between purchasing a debt that's in default and purchasing one that's not already in default?
There probably would be, I suppose, or definitions. I don't know if for purposes of this, we're dealing with defaulted debts only for purpose of this. The Commonwealth's Attorney General treats LVNV as the owner of these debts as a creditor. It's the one to whom the debt is owed.
Right.
That's a creditor under the Attorney General's perspective, and it has jurisdiction, obviously, over them as the creditor, the one to whom it's owed. So I suppose under both circumstances, it would fall within the jurisdiction of the Attorney General. And there's a bit of a balance there. Obviously, the Attorney General has its view in connection with the creditors.
Yeah, I didn't understand that. Can you explain where the Attorney General is? What's your understanding of where the Attorney General is in this case?
Not necessarily in this case, but it does under 940 CMR Section 8-03, I believe it is. It defines under its law a creditor that would include a purchaser of defaulted debt, and therefore the one to whom the debt is owed. And then the Division of Banks, it has jurisdiction over the debt collection aspect of it. And that's the definition, the common definition of one whose principal business is collecting debts, going out and collecting debts. They're the ones that interact with the consumers, the debt collector. And that's...
The record will reflect that your partner didn't help you out on that CMR site.
I'm sorry?
He didn't help you out getting that CMR site. The record will reflect.
I think I got it right, but I know it's in the briefs right.
Right, but you'll talk to him later.
We'll talk
What
about
does it mean to indirectly collect a debt?
That comes up in the second part of the definition. And it's directly or indirectly collect a debt owed to another. And so it doesn't come into play here because LVNV, if it does anything, it's its own debt. It would not be collected on behalf of anybody else. So indirectly collecting a debt, I suppose, I thought of a couple examples where that could be if you're indirectly, it comes up in 24A where directly or indirectly in the Commonwealth engaged in collection. So you may not, be sending communication. So one way it would come up is, let's just say we're late on your credit card or your utility bill or something else, and you wanted to call that creditor. There's a very good chance under our large creditors that the debt now, or the non-performing, if it was shut off, is being handled by an outside agency. It's a collection agency. They may not yet have communicated with you. So if you call and say, hey, utility company, could you turn it back on? Or hey, my credit card, I missed a couple payments, I want to get the card back. If you ended up calling in, you probably get referred to a debt collector.
Wouldn't it simpler, wouldn't be just if Resurgent hired a law firm to do the debt collection, would Resurgent be indirectly?
It could be in that instance as well. That's probably a good example too. If you're maybe an active debt collector like that and we're working with somebody else, that comes into play sometimes. There's some debt collectors that have a certain expertise, student loans for instance, and they'll handle it in part and then they'll refer it out maybe to more local agencies. So they're indirectly involved in the collection process when you're talking about the communications that are happening directly with consumers.
Can I ask one simple question? Sorry. No, go ahead.
No, go ahead.
One simple question. If you're right on your first argument, does that dispose of the entire case?
Yes.
So if you didn't have to get a license, the rest of the case falls by, we don't have 12 different complicated issues to resolve.
No, that's the best way to resolve this case, Your Honor.
Not sure it's the best way, but it's definitely, I just want to make
Lot
sure I
of issues.
understand. Yeah, that it's a domino effect for you, everything.
And speaking of resolving issues, what's your view on what the judge in the trial court, or the motion judge did with regard to void and voidable? I wasn't sure whether that was decided actually or not.
The judge did the analysis. I don't think she got to the right conclusion. Whether it's void or voidable, the law is fairly clear in the Commonwealth, and it's fairly clear across the country. There's some exceptions to it. If the trial judge who entered that judgment, whatever judgment it was, had personal jurisdiction, had subject matter jurisdiction, the judgments, and there's no due process issue, something strange that would have happened, that judgment is not subject to being declared void.
Right.
At most, it would be declared voidable.
But she said there was no other remedy, so it was void. That's where I got
That's right.
derailed.
And I did not follow that as well. It's not void. She discussed a public policy argument with regards to licensing and cited some law in that regard, but that is not the standard. The standard is fairly clear. And when you talk about public policy, when you talk about, here, for instance, the Division of Banks, who's representing and looking out for the interest, obviously, of the Commonwealth, their position is we didn't need a license. So now you're starting balancing, and the Attorney General treats this as a creditor. So it's hard to say that a public policy argument is proper, then that you would come to that public policy argument and say, oh, a license is required. When they have these other
clarification, if you could, please, on the Henson case, the United States Supreme Court case. Judge Sanders didn't have the benefit of that opinion, but are you saying that only applies to the directly or indirectly? It doesn't apply to the directly or indirectly collecting the debt?
It was only dealing with the second definition, directly or indirectly. And certainly there's some confusion about the debt collection industry. I mean, it's a somewhat newer industry over the last 15 years. It was an important enough issue to get to the Supreme Court, but they have really put to rest the application of the second definition to someone like LVNV. They're not, if they're doing anything, it's not for somebody else because they have ownership.
What's the burden on LVNV in getting a license?
They'll get a license. They'll get the license if they're asked.
If they thought they had to.
There's a burden on the state, and on page 2, the Division of Banks specifically told that in response to your inquiry. They said their position, their longstanding position, that passive debt buyers not require a licensure, And he went on and said, this reflects the division's interpretation of the governing statute as well as the practical perspective that many of its examination practices would be inapplicable to passive debt buyers who, for example, do not directly interact with consumers. So you're asking them to start regulating a whole other industry when it's not, in their view, necessary to protect the people they're out to protect. They've got limited resources, I suppose, and that's part of the reason. But it makes sense also when you follow the statutory scheme and you consider that the Attorney General also is involved.
Am I correct that your LVNV is a creditor under the AG's regs, but you're not a creditor under the definition in Section 24?
Oh, I think you could be a creditor there as well, the one to whom the debt is owed. You're not a debt collector. That's what our position
It
is.
says creditor is any person to whom debt is owed, but shall not include a person that receives assignment of debt in default solely for the purpose of facilitating collection of debt for another.
Yeah, it's for another part of
That
it.
goes back to the for another.
Yeah, at most you'd be considered a creditor. The AG's viewed us that way under their law. But the debt collector here was not, or at least we don't meet the definition here. That's
So
correct.
to be a creditor, the debt has to be owed to you.
Yes, the debt is.
And is there any regulation of you under the Division of Banking? Is there anybody who is regulating a passive debt buyer?
We're certainly under the jurisdiction of the Attorney General. They've taken action. We cited that Decadal case, for instance. On a federal level, the CFPB and the FTC certainly have regulatory authority over us. There are many states' attorney generals have regulatory authority over them. And if like I said, in response to your question, if they're told to get the license and they'll get the license. They'll do that. They're not trying to hide away from it.
And your position would be that up until now, to some extent, the Division of Banks wouldn't have processed them.
They've said that.
They said that, right?
And are you saying that the business that LVNV is in is not the type of thing that is targeted by the MDCPA? Is that what you're saying?
Correct.
Okay.
Right. Well, they don't meet the definition.
Yeah.
So, right.
What about the 128 case from the appeals court, Spalding versus LaJoy? That seems to be consistent with your position. I know it was a 128.
Right, it was. That is absolutely consistent with our position. We also cited the First District Palalis case. That was 4 years ago. It's a pretty important case. It's followed, I mean, it's, in a nation perspective, that's an important case. And there's other cases. Since the Hansen case came down, there's been a number of other cases becoming some more clarity in this field. And we've cited those cases.
All right, thank you.
Thank you.
Mr. Quad? Can't say good morning anymore. I can say good afternoon.
Afternoon. That may please the court. I'm Attorney Ken Quad. I'm here with co-counsel Joe Kulik, and we represent the plaintiffs. Respectfully, with all due respect to my brother, I feel like I'm listening to a different version of the case that was before Judge Sanders. In the lower court, LVNV never, and quite frankly, in its briefs here, LVNV never took the position that it does not meet the definition of debt collector, either definition of debt collector in the MDCPA. Essentially, they admitted that. They've waived that argument. The only issue raised by LVNV in the lower court is whether they fit within the confine of the concept of passive debt buyer that might give them a pass on the licensing requirement under the second definition, which deals with direct or indirect debt collection. Judge Sanders clearly found on undisputed facts, and again, without any opposition by LVNV, that it met each of the two statutory definitions, which are mutually exclusive.
I'm confused.
Yes.
They argued that they were the passive debt, and then but they conceded they were covered by the statute?
They conceded that
What did
that
I'd like you to be as precise as possible what they did concede, so, because you're confusing me at this point, but go ahead.
maybe concede is too strong a word. They did not did not argue in the lower court that it did not meet the plain language of the debt collector definitions. Its position there and here is only that they were not required to get licensed on the basis of the so-called passive debt buyer opinions issued by the Division of Banks. So Judge Sanders, in part because there was no opposition, but also largely in part because there are substantial facts undisputed, found LVNV was a debt collector under the first definition, that its principal purpose was debt collection. Those facts included, by the way, multiple filings with our Secretary of State in their annual reports in which LVNV described its business as consumer debt collection. It also included the undisputed facts that LVNV files thousands of lawsuits every year in Massachusetts courts seeking to collect consumer debts, and that they have admitted in numerous filings under the FDCPA that it is a debt collector.
Just to back you up on that
Yep.
point, so they have filed as the debt collector? I'm confused, because again, they're arguing they don't collect debts. Is that, so they've conceded that they are engaged in debt collection in Massachusetts?
Our position is that they have waived any argument that they do not meet the statutory definitions of debt collector. And there were factual findings on an extensive summary judgment record that, in fact, they do meet those definitions. So the only question really becomes...
But they clearly don't, after Henson, right, meet the second definition, right? I'm just trying to make sure I understand.
Sure.
Because these are all legal questions.
Yes.
Which a court has to decide correctly.
Absolutely.
I understand you can waive to a certain extent, but courts aren't supposed to waive erroneous legal we're not supposed to accept erroneous legal interpretations, are we?
Correct. No.
All right, so go ahead. Yeah.
So in the Henson case, the only issue decided by the court is whether an acquired debt, a debt acquired after default, would be a debt due or owed to another. That was the only issue decided, and that's only relevant to the second definition. Under the first definition, which speaks only to business purpose, it has no relevance whatsoever. In fact, the Henson court specifically disclaimed that it was deciding anything with respect to the first definition. Now, the first definition of debt collector is critical to this case. In finding that LVNV's principal business purpose was consumer debt collection, Judge Sanders, as I said, relied on undisputed facts in the summary judgment record, but moreover, she realized, as this court should realize, that the passive debt buyer opinions issued by the Division of Banks, upon which LVNV says it relied, have nothing to do with the first definition. The passive debt, first, I should back up and point out that the term passive debt buyer doesn't appear anywhere in the MDCPA or in any other statute here or elsewhere, as far as we know. It's an industry-created term, and it deals only with whether or not an entity is collecting directly or indirectly. Indirectly being through another, such as Resurgent, its master servicer, which it clearly does, and it admits. But the first definition...
What about the indirectly being limited to owed to another?
That the owed to another is a separate component of the definition, which was not raised by LVNV in the court below. And even though Henson has now decided that very discrete issue, it's not part of the record in this case. Getting back...
But I mean,
So...
it's not, the debt is owed to LVNV. It's not owed to another.
That's what Henson would have, that's essentially what Henson decided
Right.
in the FDCPA.
Right.
But LVNV didn't raise that issue below.
So we're to say that that's waived even though we're interpreting Section 24? And you're saying Section 24 has been waived? The definition of Section 24 has been
Well,
waived
we're only
too?
saying that in the record of this case, LVNV could have raised that issue and didn't. But the court doesn't even need to deal with the second definition at all in this case.
Okay, so we deal with the first, but
We deal with the first.
But we have the Division of Banks, which in its letter to us says we wouldn't even process it. If they apply to us, if anybody applies to us as a passive debt buyer, we would say, sorry, we will not allow you to apply as a debt collector. And now you're asking us to say they wouldn't allow them to do it, and because they didn't do it, now all of their collected debts are void.
So there are several problems with the Division of Banks' position on that. The first is, it's in the record now, but that information certainly wasn't in the record below. Another problem is, I mean, since we're speaking off the record to a certain extent, we know from other cases that they have accepted applications. And LVNV submitted an affidavit from the Division of Banks in the summary judgment record, but it didn't address that at all.
Yeah, well, I mean, it's certainly in the record that they have given advice to many people that says a passive debt buyer is not
Right,
required to
but the
register.
passive debt buyer concept, and what the court needs to understand, is that the passive debt buyer concept only has relevance to the second definition. Passive debt buyer, in the view of the Division of Banks,
Where is that stated somewhere? Do they say that anywhere in their regs, or is that, tell us where, because that's really important.
It's very important.
And where is it stated?
so it's, if you look at all of the inquiries in the record to the Division of Banks asking about licensing from debt buyers, and the Division of Banks responses, the gist of all of those has to do with whether or not the particular entity is collecting directly or indirectly. That's all it talks about. There's nothing about principal business purpose, which is an entirely separate definition and an entirely separate basis to support a licensing requirement. So all of the communications back and forth with the Division of Banks were completely silent as to the first definition. Therefore, the most that can be said that
So you'd be a passive you'd be out of one and in the other, and they wouldn't make that point saying that has nothing to do with the first one?
well, they didn't.
It just seems,
They didn't.
I'm going to go read them, but
Yeah.
really?
Absolutely, Your Honor.
Okay,
Yeah. In fact, the debt buyers, including LVNV, were very careful not to include anything in their inquiries regarding their business purpose. And the Division of Banks limited their responses to the facts presented. In fact, each advisory opinion specifies that. Our opinion here is limited to the facts presented. Had any of these companies, including LVNV, addressed the first definition, presumably this case wouldn't even be before the court.
We have any cases addressing the first definition?
Well, there's, in terms of the definition's applicability, certainly there are many in the federal system, and we've cited them in our brief, most notably the Paulus case out of the Third Circuit.
And those say that the collection of a debt to the debt collector is?
Your Honor, the first definition does not speak about to whom the debt is owed.
Right, but if you look at it in context, it appears to say the principal purpose is collection of a debt. And then it goes, or who regularly collects or attempts to collect, which I would think would mean, okay, it may not be your principal purpose, but you regularly do it. And you would think that the second phrase would be a subset of, or would be a broader view of the first, but you're saying that the first is, at some level, broader or wholly separate than the second because it's not limited to doing it for another.
Correct. They're entirely separate definitions, and if you in the FDCPA jurisprudence, which deals with the identical definition, makes that clear. For example, law firms do a lot of consumer collection work, but they're not usually established just to do that, or primarily to do that. So they're not principal purpose debt collectors. However, if they regularly collect debt, they would be covered by the second definition, not actually under the FDCPA, because in Massachusetts, there's an attorney exclusion. But debt buyers such as LVNV clearly fall within the first definition, regardless of what their actual debt collection activities are, because that's their principal business purpose.
Well, let's stop on that for a minute. So let's talk just about the first definition, principal business collecting debt. Of course, LVNV says, no, their principal business is purchasing debt, investing in debt. And then they refer to the Spalding versus LaJoy case, which refers to the recent First Circuit case, What's the response to that?
Well, my first response is that Judge Sanders, that's a factual question, that Judge Sanders resolved on summary judgment based on undisputed facts. And I recited some of them at the beginning of my argument. In the Spaulding case, the first definition wasn't even implicated. So we would put that aside and say it's completely distinguishable. It was also, I believe, an unpublished opinion. So, but again, going back to the FDCPA cases, the Paulus case, the Wadlington case, and many others that we've cited in our brief, all make the distinction between the two definitions and hold debt buyers to be debt collectors under the first definition. Of course, under the FDCPA, there isn't a licensing requirement, so it doesn't raise the particular issue here.
If it's this complicated, how's it a 93A?
So the reason this is well, first of all, it's a 93A violation because of violation of the MDCPA is a per se 93A violation.
Even with the advisory opinion?
Correct. And the reason that the advisory opinions don't insulate LVNV from 93A liability is that they, as a principal purpose debt collector, meaning an entity that is a debt collector under the first definition, neither they nor any other debt buyer in Massachusetts was ever told by the Division of Banks that it could collect without a license. They were only told they could collect without a license in their status as a debt collector under the second definition. The Division of Banks never went there, either in their advisory opinions or on their website or anywhere else. So that's
But I mean, you're asking us to sort of conclude that the Division of Banking are rather foolish. I mean, there's a definition of debt collectors. There are two separate definitions. They say you're not a debt collector, and you're saying, oh, we only meant B. You are a debt collector as to A, but we just didn't say that. I mean, it's a sort of a bizarre view that the advice that the Division of Banking would give is that you don't qualify for B, and we're just not going to mention that, oh, yeah, you do qualify as A, but we're just not going to tell you that that's the
I
case.
agree with Your Honor's characterization of it as bizarre, because even under the second definition, it's so patently clear that the advisory opinions directly conflict with the plain language of the statute. The statute, with respect to the second definition, treats direct and indirect collection activity equally. The language is directly or indirectly. LVNV admits it collects indirectly.
Okay,
It admits that.
But it does not admit that it does it to another. It does it to itself.
Well, again, that's new in view of Henson.
You know, as I look at this, it just seems that this concept that has been mentioned of passive debt collector, or passive debt buyer, rather, not collector, but buyer, wasn't contemplated by these two definitions. That the first definition would apply, say, to Macy's trying to collect its own debt, and the second would apply to a collection agency or a lawyer collecting on behalf of Macy's. And we don't have anything to encompass this concept yet of passive debt buyer.
Well, there have been cases which have tried to explain what a real passive debt buyer is, which is a company that buys and holds debt to resell it or for other investment purposes. Their principal purpose isn't to collect on it. There was a stipulation in this case that over 99% of LVNV's revenues result from debt collection. To your specific example, Justice Cipher, Macy's wouldn't be a debt collector under the first definition because that's not its primary business purpose.
Okay.
Their primary business purpose
You're
is
right.
to sell merchandise.
You're right.
But LVNV fits precisely within that definition.
So then why do we need both definitions?
Well, to cover two different kinds of companies. So, for example, the first definition fits perfectly with LVNV's business. It would also fit perfectly with a company whose primary purpose, a collection agency that might not collect debt very often. So, for example, in the second definition, there's the qualifier regularly collect debt. So that's why the first definition exists, and the second definition exists to apply to the conventional collection agency. The statutory scheme makes sense. It's been applied without controversy since 1977 in the FDCPA context. The other reason why LV,
Afraid you're out of time, but I'll give you the last,
Well,
your
thank you
last
thank you, Ron.
final thrust.
The other main reason why Section 3 of 93A doesn't protect LVNV is that essentially what the Division of Banks has done is allowed LVNV to engage in activity that the legislature said was illegal. Under 24A, no business may participate directly or indirectly in debt collection. And this has nothing to do with the second definition. Once you qualify as a debt collector under 24, then under 24A, you can't operate a business directly or indirectly to collect debt in Massachusetts. So that's where the licensing requirement is really seen as ironclad, and where the Division of Banks essentially, in these passive debt buyer opinions, rewrote the statute. It took the indirect part of the statute out, and it's just as prominent as the direct collection part. And as the court has seen or will see in the briefs, other state Supreme Courts which have confronted almost this exact same issue in the licensing context in Illinois, in Maryland, in Arkansas, have seen through the industry-friendly passive debt buyer opinions that give cover to debt buyers from the licensing requirement.
Okay, great, thank you.
Thank you very much, Your Honor.